And we have a quorum of zoning board of appeals. Woody Chidick and Leah Fernandez are going to act as full members tonight. And Lee Darst will be an associate member. We have 3 full hearings on tonight. And not really any old business other than minutes. So let's start with a roll call. Dave McMorris here.
Woody Chick here.
Lee Darst here.
Leah Fernandez here.
The first matter before us tonight is 91 and 95 Elm Street. And who's presenting on that?
Awesome. So, but I just want to give you guys the forms that you will be following.
Okay,
Okay.
And I'm Bibi Alzheim, by the way, his wife. He is suffering right now from having fallen and hurt his back and spine. So he's kind of having to sit down.
we have a microphone that we can bring. Yeah.
Should I take it over to him now?
He's kind of,
Oh, here it is. All right, thank you.
all right,
Okay, give me enough time, just present my case to all of you over there. First of all, good evening, all of you, Mr. Chair, member of the board, and neighbors present this evening. I rise tonight not with conjecture or speculation, with evidence created, signed, and preserved by this very town. Every document in my binder, every exhibit before you comes from the building department and inspectors and the board itself. The dwelling at 95 Elm Street was a lawful, pre-existing, non-conforming residence. That's not my claim, that's the fact your own records confirm. It was assessed year after year with the tax rolls. It was recognized in the permits issued by your office. Its demolition was not an abandonment of rights. It was the direct consequence of municipal action, as shown in the revocation letters and inspectors' reports. Tonight's petition does not seek expansion or intensification. It seeks only restoration. Restoration within the historic footprint and network, exactly as the law permits under Massachusetts General Laws, Chapter 40A, Section 6, and where hardship must be shown under Section 10. Statement of facts and precedents. 1. Historic continuity. Tax records and assessor's cards confirm continuous recognition of the dwelling at 95 Elm Street. Photographs and certified plans establish the pre-demolition footprint and dimensions. Signature line. We did not come here empty-handed. We come with facts drawn from your own files. Permit trade. 2. A building permit was issued by this town, acknowledging the lawful status of the dwelling at 95 Elm Street. The permit was later revoked, not through any fault or abandonment by the petitioner, but by municipal decision. Inspectors' reports from your own department confirm this chain of events. Signature line. This is not my evidence alone, it's your evidence signed and recorded by your own town departments. Computer evidence 87 Elm Street. The board granted a special permit for larger development at 7 Elm Street, just steps away. The approval signed by you stands as witness tonight. It demonstrates that when evidence is presented, the board was granted relief consistent with both Section 6 and Section 10. The record now speaks louder than any argument. It's not we who must explain ourselves tonight. Hardships, grounds, Section 10. The parcel at 95 Elm Street has unique shape and grade constraints limiting the building envelope. Without relief, the owner faces undue hardship, permanent loss of protected residential use despite a lawful record. Relief can be granted without detriment to the neighborhood and without nullifying the intent of the bylaw. Legal precedents. Bransford versus ZBA of Edgartown, 444 Mass, 852/2005, which stated, non-conforming rights survive involuntary demolition. Reconstruction is reserved as of right. Goldhurst versus ZBA of Beverly, 27 Mass, Appeal Court, 563, 1989. Reconstruction without intensification is protected under Section 6. Jorkland versus ZBA of Norwell, 450 Mass, 357/2008. Boards may impose reasonable condition, but cannot deny outright absent substantial detriment. The signature line here is the SGC in Bradford preserved the right to be built after involuntary loss. In Goldrich case, it's protect the reconstruction without intensification, and in Jorkland permits condition that the condition but not denial, absent substantial detriment. My closing statement. Member of the board, the petition before you is not an invention. It's a matter of record. The approvals and the signatures that shape this case are not mine, they are yours. They are the board's actions, the building department's own letters, the inspection or the inspector's own reports. The consequences of those documents are undeniable. They establish beyond doubt that 95 Elm Street was lawful, that its demolition was involuntary, and that its restoration is both protected and fair. To deny this petition in the face of such evidence would not merely be error. It would surpass the impossible. It would disregard your own signatures, own approvals, your own record. We ask only for fairness. We ask only for what the law already protects. And we ask that you recognize openly and for the record the undeniable consequences of your own documents. And thank you.
Thank you, Doctor. Help me pronounce your last name. Is it Elzaim? Elzaim. Looking through the application materials, there's a whole list of, first there's where you're supposed to fill in what the existing setbacks are, all that kind of stuff, which is not filled in. There's also a list under plans that asks for 8 copies of a site plan, lot lines, dimensions and lot area, structural building calculations, zoning districts, locations and dimensions of all buildings, including ones next door. We don't have any of those things. And under architectural plans, we're supposed to see architectural plans of what you intend to build. It's not enough just to say, I'm going to build what used to be there.
Section, excuse me, under section 6, chapter 40, I'm only asking for my rights. I'm
Well,
not
we'll-
asking for anything else.
we'll get-
I'm
we'll-
not storing.
We'll get to that in a moment. We have these requirements in our applications for a reason. We can't tell what it is you want to do without an accurate site plan and accurate architectural drawings. Mr. Hallen, who's the building inspector and building enforcement officer, can't know whether or not you're complying with what you've planned without plans. So that's why we require these things, and it's not enough to say, well, I don't have them, and give me a reason why you don't have them.
If you don't mind, I provide the site plans and I can review it.
Now, I have a site plan, but
So,
it's a,
about the three-dimension, I just told you, the house already demolished, there was no way to measure anything.
well, you want to build, but you want to build something back, right?
The same house.
Well, we don't remember what it looks like or where it was. That's why we need, now that doesn't, we need to know the dimensions, what the setbacks are, what the height is, all of that. But just before we get to that, here's the problem that I'm having, and I don't think it's a problem that you're going to be able to get past. 308.7 is abandonment. We're not talking about abandoning your rights. We're talking about abandoning the building. Once abandoned, a non-conforming use or structure, and this is a non-conforming structure, may not be revived or resumed. A non-conforming use is not pertinent here. Discontinuance of a non-conforming residential use for more than 3 years or discontinuance of any other non-conforming use will be deemed abandonment. That's the use. The building itself, a non-conforming structure that has been left vacant and unmaintained for more than 2 years will be deemed abandoned and may not thereafter be altered or used until brought into compliance with the regulations applicable to the district in which it is located. Have you read through that already?
Yes.
Okay. Okay,
I give you all this document, you have the permit issued by Robert Egan. And you can read his letters and you read why this house was not from day 1 or 12/6/2019.
that's when it was boarded up, right?
12/6/19, he issued this permit.
That's fact that the town had to board it up doesn't help you to show that it wasn't abandoned. Yeah. Sure.
You read this, it's give you all the answers. He acknowledged in this. He acknowledged in this permit that the house is sound, that the house is livable, the house is in good shape, and it is only $10,000. It's written here. Just to fix it.
Okay.
And then, because I did not hire his friend, he revoked it, and you have it on page 2.
I don't think that's what it says on page 2, Doctor. That he didn't hire his friend, so he revoked it? I don't think so. I think what it says is you had a building permit to do a particular thing, which was boarded up, and you didn't do that, and you had sent somebody to do a bunch of other things. So I did read it. So he-
He said, here, if you don't hire this man, I will void it. What does it mean to you?
He said, you need to hire the person to do the work that you got the building permit for. And you had other people coming in to do work that was not part of the building permit. That's why it was revoked. But that doesn't really matter because when that happened in 2019, no one had been in that property for at least 5 years? That was 2019. There was nobody in there then. 2020, there was nobody. 21, 22, 23, 24, 25. It's like 6, 7 years. Since the boarding up order, there's been nobody in there. It's abandoned. It had holes in the roof. Nobody could use the property. That's an abandoned structure. Whether, there's, whether,
I'm a physician.
I understand.
Educated also consumer of things. I can read and explain to myself. I can talk to million people also to read my things. The question I'm asking here is my rights. I don't dilute my case. I need my rights under Chapter 40, Section 6.
Well, you can, I know, but you
By law.
you are protected by law and by our bylaw. And our bylaw is very specific about what you are, your bylaw is very specific about what you are and are not allowed to do. This particular building, one of the things that you're allowed to do and required to do is to give us an application that meets the requirements of the application. The second thing you're required to do is to comply with what's inside this bylaw. You have an abandoned structure. You no longer have any grandfather rights for that structure. If you want to build on that lot, you have to have the front setback, the rear setback, and both side setbacks. And then you can build on property that's within those setbacks.
Can I answer you?
Sure.
I think you're wrong.
Well,
I'm not saying wrong. I'm not a lawyer, but I can tell you that from logic point of view. If it's written with these documents, and if any lawyer in any place in this country can read it, you will never issue a permit if you don't feel the place is safe. That's number one. You cannot deny that. And he wrote here, secure, stabilize, and build, alter, and demolish. So if he didn't feel that the place is safe enough, he will not demolish it. That's logic or not? Tell me. And number three, he said the cost will only be $10,000, and that's more than enough to make the house livable. And now you are denying this. So if you felt the place is abandoned, he will not issue this.
the permit wasn't to make the place livable. The permit was to make the place safe for passersby and to keep animals,
No, that's-
children, and other people out of the building. The building permit was to board it up. You don't board up unabandoned buildings.
No, you're wrong.
And even,
Because you are not-
even if that's true, even if it was a livable structure in 2019 and the building permit was for a livable structure, it wasn't used in 2020, 21, 22, 23, 24, or thus far in 25. That's more than 2 years. That's an abandoned structure.
I think in court of law, in Norfolk County and the Superior Court, can you answer that at that time? That you are saying it was abandoned?
Absolutely, it's abandoned.
With all this proof in front of you, respectfully, you are a lawyer, but I think there's always someone above us.
Oh, I'm sure there is, but I think that
Massachusetts, it's very protective.
it's not protective of abandoned buildings.
You changed
It's,
the whole equation and you said it was abandoned for 6 years.
all right, let's do this. Let's start with this, okay? We opened this hearing because the town clerk accepted the application, all right? We have an application that is completely deficient in many, many regards. You can withdraw the application without prejudice and come back with it, one that complies or not. If you want to go forward with this hearing and go forward with this application, we will do that. But this does not comply with what we require. Everybody else, everybody who comes before this board has what's required in this application. Everybody does. The project that you're proposing is a very unusual and it doesn't comply with any setbacks. It actually goes out off of your property a little bit, what you propose to build. It's not the kind of project that you're gonna go through on a couple of pencil marks on the application. You're gonna, if you want to build, you have to come here with an application that's filled out. You have to come here with a site plan that meets all the site plan requirements. You have to come here with architectural plans that show us exactly what the building's gonna look like and where it's gonna sit. And then we can make consider that and decide it. But I will tell you that you do not, according to our bylaw, you don't have any rights to build anything except a conforming
I'm
building.
not for one thing. I'm protected under section 6.
I understand that, I understand that that's, I understand that that's your reading, okay? But section 6 is a little piece of the zoning law. The rest of the zoning law is mostly in here in our local zoning bylaw. I'm sorry, what?
What you're writing in your locals has to be according to Massachusetts law, right?
Absolutely, yeah.
And it's already been approved by the Attorney General.
If I am protected under section 6, how you are telling me I must?
You're not protected under section 6. Section 6 doesn't stand by itself, and you have no protection under section 6. You have an abandoned
Can
building.
you write this?
You have an abandoned building, and when you abandon a building, you lose all your what's called grandfather rights. You've lost them. You have a property now, a lot, that's of certain dimensions that you can build on if you can build within the conforming setbacks. That's what you can do. And when you do it, you need to come here with an application that actually meets our requirements. I've said what I need to say. Anyone else on the board want to ask some questions or?
I think I would like to, there are members in the audience who might shed some light on some of this, but I entirely agree with you.
Okay. I'd like to introduce myself. I am Mrs. Alzine. When my husband went and buy that property, he bought it for me because he knows I like water. We lived 40 years in Braintree and we're far inland. Where water is, we have to drive out about 20 minutes. So he bought it as a surprise for me. And he was there every weekend, building stuff, adding stuff, breaking stuff, whatever, and trying to build it make it livable. So he would bring me, he even has a toilet, portable toilet, he brought it. So he was there every weekend practically. If you check the mileage in our car, where is go the, what they call it, the GPS, it's there he's going. He's a doctor with a very soft hand, but he bought all these equipments and he was working on it. And then it was taken away from him. And that's when he showed me that he bought this for us to have water view, because I like water view. I used to live in South America by the water, the Atlantic Ocean. So he always wanted to give me something we can afford. He could have afforded that only. He couldn't afford one of the 2 million buildings. He's a solo doctor working hard. That's all we ask now. Can you please let us build something there? Don't make it difficult for a single family, him and me. Our children are all grown. Your children are probably grown. And he just wanted a water view for me. That's all. So please make it not so every little dots and cross T. That's what you are doing.
These are not dots.
You are creating a difficulty for him. So he cannot build anything for me.
These are not,
So he cannot do any, let me have my talk, please. This is US. We're not in a Russia or somewhere that I cannot talk.
you can talk.
Please let me continue.
Please.
So I feel that all of you sit here, I saw the expression, I took the picture of all of you, preconceived the idea, whatever of that big building 87 there, you're giving him access to our lot. You have pulled it down, you have knocked it down, you have filled it, and you're giving him a view so that he can look at the waterway. And his people that he's selling $2 million property will enjoy that view. But we're the losers, right? Because we're poor. We don't have money. We don't go to, what you call it, play golf with him or go on his yacht. But I'm sure the records show, all of you know him, right? All of you know, and I can tell you this, eventually I am behind him now. He was before alone. He's not anymore alone. All right, God and him and me. Because you people think you're in charge of the universe. He just bought that for me so that I can enjoy a water view. So therefore, I'm begging all of you, please let my husband build a little house there. That's all he's asking for, a little house. So we can walk across to the beach, to the waterway that you have built for a million years. We are the poor one there. And you have already built for a million years. Just let someone poor do it.
As I
Thank you.
said before, if you come back with a proper application
I think you
for a structure,
You
which
are nitpicking. You are nitpicking not to give him a chance.
enough.
Face the fact.
Any other questions,
No, no.
Leah?
I have some questions.
Yes, please.
I'm very new to the board, so this is my second meeting. So,
Oh, okay, welcome.
so I don't know
You don't
anyone.
know
I don't know the approvals. I don't know
6
the,
years history.
sure. So the one thing that I have questions about, and again, these were submitted with all the information, all the emails instructing from the Cohasset Building Inspector saying you need to make the property safe. Why was all that ignored?
No, it was done. He was there every week. But let him answer you because he has better.
Sure, well, I guess I shouldn't say why was it ignored, but it seemed as though the building inspector was very clear of what you need to do in order to rehab the building.
It was a conspiracy. Using it even now public, conspiracy, from day one. I approved even the town manager, that everybody here.
Yeah.
I sat with him and he refused, even to help.
Yes, because 87, the multimillionaire ones, won that plot for what? View.
Because 87, George is the friend of this
Right.
guy, David McMorris.
Yes, and they go
Let it
on his
be
golf
public
course.
when we finish. Let me public make it. Let everybody knows. I
Mhm.
open it.
Yeah,
They know each
Yeah.
other for 6 years, and that's what George told me. And their daughters together,
yes.
the school and
either
everything. And
regardless-
I had emails. I
We
kept it
have
from
George
George
who
that he
said-
has contact with
George
you.
had said it.
All right, that
You
you
know-
have. Now, this is conflict
This
of
is
interest.
conflict of interest.
By law.
Yes.
You are responsible. You cannot be double the standards. I have all the documents from George about you.
So
You know
the,
that?
so
Yes.
the
You have
only,
this connection with him.
the
Listen
only,
to her, she wants to ask.
the only formal,
This conspiracy not to allow me to build, starting with the first one. He issued the first one and I went to the town manager and I met him. And I said, look what he's doing. This is completely abuse of power.
Think
This is
about it.
misconduct.
Think about it. How do you feel in your conscience
And
letting
he
this
said
go?
nothing.
How you can think about it, kiss it up to the rich, because you can give us, we don't have that kind of money
We-
or
Stop,
wealth.
stop.
Let him talk.
Stop. You're not going to accuse us of any of that stuff. No, stop,
We
stop.
will-
Hold on.
Both of you,
Facts.
both
We
of you
have facts.
stop.
We have facts.
Okay, we will take a vote to deny this application
Exactly.
or approve it right now unless you can act appropriate. Okay, you don't act like that in here,
Okay?
all right? You're polite, you're soft-spoken,
Yeah,
you're respectful,
right.
or you can leave, or you can leave.
What you doing right now?
Okay.
I'm talking to you. Stop.
You are threatening us.
I am not threatening
You
you.
are threatening
I'm-
us. We are free citizens.
I will tell you this, okay? We have rich people in this town.
Mhm.
We have not so much rich people in this town. We have people who want to build big houses. We have people who want to build small houses. And every one of them has to comply with the Cohasset
Yeah,
zoning,
yeah.
with the Cohasset zoning bylaw.
This from you. This from you.
And if they don't comply with the bylaw, they don't build, period.
All this proof in front of you, you turn it around like I would have done. Completely.
What do you want?
Because if you are sitting behind this table, I am now, I can dictate. Because this one sitting here has no meaning. So I can put him down. You want to deny it or deny it with the?
I don't have any personal feelings about you whatsoever. Okay, my job and our job is to take the bylaw, take the applica-
You refuse to.
you're interrupting,
And this is public, let
You're-
it be public, because
you're
I'm
in-
going to take it public. even.
you're interrupting.
I put it with the paper.
Sir,
Because you did, you said-
Sir,
This is what he did last time.
I was
sir,
just asking about the exchange back and forth between you and the building
Then I
inspector,
tell you.
who was only asking you to make the building
second
safe.
Inspector came
And I
after
was
him, he
curious-
took the case inherited from him, and that
It's okay, I was
decision
just,
continue.
again, as a new member, this is my third meeting, I was just curious with the back and forth, what had happened if you were given the guidelines in order to make the house,
Followed everything.
the property safe, but there was no work done to make it safe.
Give it to me and I follow
So,
it with that.
so all the notes then on the application, which again, as a new member, I'm just trying to
No, it's fine.
go through the application line by line, and all I see are these, well, the town did this, or the town did that, and so they're just notes, but there's actually no
I'm
number,
Asking for my rights.
I
under
know.
Section 6.
but this
Nothing
board
else.
will only,
Give it to me and that's it.
the
So
board,
don't ask me different questions.
the
Don't
board
tell
is
me I
only
need
gonna look
measurement,
at
I
the
need
numbers that are on the
This is going to be
line.
public. This is going to be public, and I'm going, and believe me, to print all the emails I received from what's his name, George, about you. And you'll see in court of law, I'm not threatening, but in court of law, because I'm going to appeal everything, that how this kind of friendship, you give it to 87 and you deny it for 95.
I would ask
If this is going to show, at that time, all of you,
this
I
guy.
have the paper from all of you, because of public records,
okay.
that you agreed and you signed
All
on
right.
it.
Is there anything else that you'd like to add to your presentation at this point?
Well, one thing.
Is there anything new?
I know that he had work in there and he has all the equipment that he took away, put it in our garage.
Mhm.
And he was strengthening the eaves, right? What is it called that you were strengthening there? Some of it was rotted, so he cut it out himself. He was doing a DIY. All right, we're not rich enough to have contractors with millions of dollars. So he was doing lots of work and stuff. You know, and I don't know, I wish you had taken some pictures of it. He cut in the rotten pieces, put it himself, replace it. That's what he was doing in there, from there. Okay, now the glass broke at the front. There was a huge glass. And that's where you saw that they had to come and replace it with board. They boarded it.
Boarded.
He boarded that because the glass had broken, not because he didn't comply. When the glass broke now, instead of he bid it, then he called us and sent us the charge for it. I have that bill, right? You give it to me. Yeah. So that's what happened with the board of business.
The town
That's all it was.
the town so successful in punishing the poor people, because that one boarded and sent me the bill.
Yeah.
And this majesty here, well, he sent me the bill $28,000, and he put a lien against that. It was so easy just to go after the poor guy. Did they do it in 87? No, because he's in Black Rock County.
Yes.
You know, he has what, all of you go there for what? For,
Dinners.
to play for, have dinner and play golf.
No,
And we are friends, all of us.
I truly, like,
I know the story because I have it from George himself.
I'm a
So he
young,
goes in and that's what he does, cut the rotted part, fix it.
yeah,
And so I have all the tools.
no
that
matter
he
what,
did.
I think my question,
It was a DIY.
So
I think-
as a
think-
member,
We gotta.
my
She-
questions
She has questions.
are.
Please listen to her, listen to her
I
question.
just had to finish talking.
You did, thank
Give me a
you.
moment to finish.
You did, thank you.
My,
So-
my questions were very specifically about the work, and it says that you might have done work to try and fix it,
Yeah.
even though there was still, so regardless, it sounds like it was still abandoned. And it actually doesn't matter, I think, at this point, because when we get back to the true
Yeah.
black and white on paper, an application needs to come to this board,
Mhm.
and the notes on the application are the only reasons I asked the question, because it said, the town knocked this thing down, the town did this, the town did that, the town did that. But it kind of doesn't matter, because in order for us to approve or deny anything, the actual application has to be filled out.
Yeah, we had to cross the I, dot the T.
But let me
But
ask you a
let me
question,
finish one
ask you a
thing.
Yeah,
question.
and that's the only thing that we can
I
make a
will
judgment
ask
on.
you-
We can't make a judgment on anything else.
Mr. O'Hara,
He
the
shouldn't
people inside the
start
building-
taking over.
All right, enough,
No.
enough. Okay. Jeff,
I don't have a hand up. The doctor here had previously approached me about this, so I probably have a bit of a conflict.
okay,
Things I would add though. I'm wondering how you could abandon a farming use as opposed to structure. Structure exists, so that's the first, if we were to consider the application, I would think about.
Mhm.
Like you said.
okay. Does anyone else in the audience have anything they want to add? Anyone on Zoom?
Not seeing any hands raised.
Okay. Anyone on the board have anything else?
No,
Anything you want to add that you haven't already said?
The only thing I can say is I need my rights as a citizen, as a law abiding citizen. I'm under the law protected.
Mhm.
You can do it around what you want to explain it, that's your right. But my right is, I need my rights back.
Mhm.
Now, you told me you have to have this, I follow exactly what Jill told me. What I got from here, I follow. I follow exactly. So when you tell me this is minus, this is this, I wrote this what I mentioned because the building is already demolished. Who is going to, how are you going to measure it? And he is acted like hiding the, covering the hatchet. He quickly covered it with everything. How are you going to measure anything? Just tell me, I mean, come on,
Do you intend to build something there?
I need the exact house, that's it.
That was.
Well, how are you going to build this exact house if you don't?
969. Why? And there's 10 units beside me exactly.
How are you going to build a house with no plans?
Well, that's. we
Just
want
give
to
me
be
approval.
okay, that
No, no,
it's
no.
okay.
That's not how it works.
that
we approve-
have the right
We
to-
approve or we disapprove plans. You can't build a house with no plans. If you had a plan to build a house, we could look at it and we could say, okay, this doesn't work, okay, this does work, okay, this, okay, that. But we can't do anything with nothing. And that's what you've given us is nothing.
Excuse me. You just mentioned earlier, everything recorded. Probably you forgot what you said before. You said the place is abandoned 6 years and you created complete scenario. Now you are telling me, what are you going to build there? What are you going to, you see how you contradict yourself back and forth? Probably you're not watching what you say.
A
Give me
900
my rights.
900 square feet house.
969.
Living room,
What's
a
bothering you?
kitchen, that's
What's
it.
bothering me?
Yeah, why?
Why
You've
we
given
can't-
us nothing in the application that you're required to give us. So we have nothing to consider.
what is the zoning district that this is in?
Look, you have the papers. Do I have to teach you?
What is the zoning district?
Do I have to teach you this?
You could answer my question.
I'm telling you, I'm answering you. If you open this, what he has, you can.
He
read
doesn't have it
This
in
meeting
exhibit.
himself, excuse me, he did not review it.
It's in the Harbor District, right?
Okay, how you signed it for 87?
har-
The house allowed in the Harbor District by right?
Yeah.
No.
It should be.
It's not
Can you
allowed.
tell-
House is
can you
not
tell-
allowed?
what's your name, please? What's your name?
My name is Chittick,
No, give me the whole name.
Stanley Chittick.
All right. So when we go to the court together and you tell the judge, and at that time, tell him, because if you are a lawyer,
Well, there-
tell him,
Let's just talk to these.
tell him because you are taking advantage of a physician.
All right, that's,
All right.
okay, let's,
I'd like to-
that's enough.
Okay.
Can I
we
make a
need-
motion
We need to
or
move
not?
forward. You
Yeah,
have-
we got
you
other
have
things on
you have
tonight.
Yeah.
A choice.
Can I
You
make a
can
motion
either
or just don't you
withdraw
need to?
your application without prejudice, meaning that you can bring it to someplace, you can fill it in, you can comply with it. We have told you over and over again,
You told me.
we,
I know you.
you have not,
Do I know you?
Stop.
I
She's
am a
speaking.
board member.
No.
She's speaking.
We have explained to you at least 5 times that your application is completely deficient. We cannot vote on your application as it is. We are offering you the chance to withdraw your application without prejudice, meaning that you can file it again. If not, you're giving us our only choice, which is to vote on it as it is, which we've told you it's completely deficient. And then if that happens, then we would deny it.
Okay.
So you have the choice right now to withdraw it. We have told you the whole
Deny
thing.
it. Deny it, it's fine. I wanted to deny it because we going and I'm taking all your names and your connection to George
Move back.
at that time.
Move back. Move back.
You have to,
I'm
you
not-
have to, no,
Move
no, you
back.
have to move back.
Let's go.
Dave, I really would like to make a motion.
Let's go.
Deny with prejudice.
You
Yes.
prove, you prove who we are.
All right,
Okay,
this is
you can do it
we have
with
a-
prejudice.
a motion to deny with prejudice. Is there a second?
Still got it with prejudice?
Second.
and we'll let it go.
All those in favor of denying the application with prejudice?
What he needs to
McMorris,
do.
aye.
Stanley
Okay.
Chittick, aye.
Guys.
Lee Darcey. You didn't have to vote.
What am I specifically voting on?
To deny with
To deny
prejudice.
with prejudice.
That's 45 minutes. I'll never get back.
Yes, I mean, you cannot. Or do I have to vote
Well,
tonight?
Well, I guess you can abstain.
and then do you want me to? Oh,
I don't think we can do that, but it's a 2-0 to deny, so.
Okay.
You can
Okay.
abstain if you wish.
What? I'm sorry, Dave, what are you saying?
Leah,
They're
Wants to know-
looking to me for a vote and I'm not sure that I know exactly what I'm
We're-
voting on.
the motion is to deny this application with
And not let
prejudice,
them
The
apply
way-
again.
the way it is.
The
yeah.
way the application is written,
Right.
there's nothing I can vote to approve, so yes. Leah Fernandez,
Right,
I
and,
vote
and he did not
aye
want
to
to withdraw,
deny
so
the application.
we satisfied his
as it
request.
stands.
Okay,
Yeah.
Okay.
And he has to now wait 2 years.
does. All right,
Next year.
the next item is the Joy Street dock. And that's application for a special permit dock. Applicants are Andrew and Kristen Astley. This is at 45 Joy Place. Jeff, you're representing them?
Yes.
Okay, go ahead.
Paul Seaver, the Bacon Consulting.
You have to say
Uh,
your name.
Yeah, we were originally in there. Thank you, Brian. It's a simple dock application. The dock meets the requirements. The bylaw, because we're in the floodplain water protection district, is a special permit use. That is in connection with an allowed use, which is recreation. It is less than 20 feet in height and the ground coverage is well below part of that level. But I'll have, if you like, you can have a call. Plan, and the Conservation Commission, the commission would approve, the rate and application. The plan is, whenever this file with eyes. Those revisions, I'm not sure that you way into your packet or file last week. But essentially, with make clear that we're not works people or any other than to construct the dock. Reduce the length of the dock to address a concern by the butter. That was articulated to Conservation Commission. The butters potential right back this little harbor off the left side of the dam. We've moved the rocks and others of and that's pretty much it. I don't know if you want to make Mr. Seaberg or not.
Just a quick question. I see the proposed float is 10 by 16. I know I saw it 20 by 20 someplace, but So that's the current plan, it's a 10 by 16.
Yeah.
And what's the length change to?
Yep. So it changed to 108.7 feet. Is the total length of the dock structure.
One,
Whereas it initially was proposed to be around 140. 120.
yeah, 120.
And just another point of clarification, is the riparian division line also the lot line?
The riparian line.
The dotted lines on either side of the dock?
So this is
Of the-
registered land, okay, and the
Yeah.
registered parcel. Goes like this. Okay, the land court. Does not register land. Seaward of the high water mark. So oftentimes I run into this where. A deed recitation says something beyond. What is registered. And what we do is we break it into a registered and an unregistered parcel. In this case, the survey was initially done on the entirety of this. And Paul can explain why he did that. I'm not gonna explain that. He'd like to address it.
Sure, and when you explain it, I'm interested in knowing, do they own any rights below the mean high water? Are they building on land someone else owns? Do other people have the right to build there too? Docks, et cetera?
So based on our survey, our professional land surveyor is referring to the colonial ordinance of 1641, which the owner of land bound by untitled waters has title to the shore or flats to the low water mark, but no further than 1,650 feet or 100 rods. So the method our surveyor used to determine those riparian division lines is the colonial method, which essentially is you connect the line at the mean high water line at each side property line and draw a line perpendicular to that as it intersects the low water mark. And if there's any overlap between abutters, then that's divided and shared between the abutters. If there's a gap, then that would be divided and shared between abutters. The idea is to give people equal access along that water line.
But we're not proposing to construct any portion of this dock on land owned by anybody. Any other individuals or. There's no deed for that land.
Is it owned by the town of Cohasset, possibly?
I haven't seen a deed that says it is.
Okay, I mean, I
No.
don't know.
I guess usually when we see these, the property line is drawn and then it's extended out into the water at the same as a continuation.
Yeah.
This one seems to be, took a little jog, and then if you took it straight out, it would be cutting right across the dock. And I don't understand what's the,
That's the method.
this is the colonial method?
It's not, drawing just a straight line out to the water is not the correct approach to determine that riparian line.
We don't have in front of us the, a person who's, I guess, what, 40? Joy Place, who's got some issues with this. But he talks about a deeded property right that goes into this, below mean high water.
Yeah, so.
So that must be, it's deeded. There must be a deed somewhere.
Well, on the, probably.
Woody, this is Andrew Astley on the line. I'm the owner of 45 Joy Place. The title that they're referring to, 40 Joy Place, Brian Nelson, is a easement over 45 Joy Place's property. There is an easement to the left side of the property at the sort of in the middle of Joy Place as you go northerly. And Paul, who's there in the room, can show you that on the diagram.
So, can I move forward? Okay. So the record plan at the land court is here. Now,
Well, I think we gotta share it.
Is that the one that was submitted today?
I
I don't know,
was,
'cause I couldn't read it because it was a photograph.
That was, I didn't,
this is a larger version of it.
Was this it right here?
For my failing eyes.
That was the one that
Here, you want a
Nelson.
small version?
No, that's,
Yeah, I could do small.
that's not the land court plan.
Okay.
yeah, there you go.
What's this one that you provided today? This Mr.
I
Nelson?
didn't provide anything.
No, Mr. Nelson provided it today by email.
I don't know. I'm not privy. I didn't
This
see.
is, what's this?
This is the land court plan.
So what I wanted to show you on the land court plan, okay, is that the property that we're talking about is property Z3.
Okay.
Okay, and if, where's the north arrow here? Here it is. If you focus in to this spot right at the corner, I'm just gonna put my finger on it for each one.
The 15.
Yep. That is a 15-foot wide way, which is there to provide access to Little Harbor. Now, back in 1950, 50, thank you. Little Harbor, at least at the time, was surveyed to be this kind of hook like this. Okay? That is not what it is today. So there's been, I don't know if the technical term is called accretion, where it's kind of the reverse of erosion or what, but the low water mark of Little Harbor is further in this
Way out
area.
there.
So this, what our land surveyor has done, has taken this right of way and extrapolated it on the plan that was filed to you. Am I right about this, Paul? Did you go here?
This is an older version, so the newer version has this line extending out. 15-foot strip. I have a couple copies I can pass.
Yeah, I think that's very helpful if you could show it.
And its
So that we,
plans are supposed to show rights of way.
yeah. You're right. The right of way would extrapolate out this way, not really.
That has the right of way?
Yeah.
That one does. Yep.
Oh, I see, okay.
Thank you.
Oh, yeah.
Yeah,
Yes.
so I did not see the email that was sent to you today, but my
Right away.
guess is
Here.
that it probably references right of way as the land right. And not the actual fee ownership of the property.
And he had certain concerns about ability to, you know, access the water or launch a boat, but he provided no evidence. I mean, it was a statement
Yeah, I'm pretty sure.
of concern, but no,
I know factually that this property is subject to the right of way, not as we extrapolated it, but as is shown on the registered land plan, which really is a very short distance of,
oh,
from here to there.
Wait, where is it?
We,
Where's the right of way?
right here, so this little spot, right where my fingernail is, that's the width of it.
So where is that?
This, on the new one, this is this dotted line down here. It's not on this one.
No, but this, right here, that.
Yeah, is this corridor,
Yep, we extrapolated it
Like
out,
that,
but it's really
the
only
dotted line
this
would
area
go like
here.
that. So if you were to overlay them,
Mhm.
like it would be the little dot there of that tiny 15-foot. I shouldn't say tiny, but of that's not insignificant 15.
and the registry of deeds has never
that correct?
changed any
That's my understanding.
plans or anything. So
No, the land court hasn't extended that right of way I do think that there is an argument that it does extend to the mean low water mark. Which is why we reduced the length of the dock to make sure that the two could coexist if it does actually extend
Is
out.
this the reduced length dock?
Yeah.
Okay.
And
So
I know
this is
that, I
the
know
one
it's
hundred
confusing.
and 14 or 108 foot dock
180.
180. plus the 16 by 10
Yes.
as opposed to the 10 by 20. I think that was originally
Correct.
submitted. Okay.
You have experience with titles?
Do I?
Yeah.
Mm-mm. I mean, I own a home. We have an easement, a right of way, so I'm familiar with how we went about obtaining the information with our lawyer when we bought the house, just to make sure that we could always access. And yeah, if someone put something in front of my easement and I couldn't get my car in, then would be concerned, so. That's the only experience I have. With easements and such, so I understand the note from the neighbor. And so if the dock does. Cross over the easement, then. Yeah, it's, I would be concerned too.
However, this is Andrew Astley again. I'm sorry it's hard to raise my hand from afar. As was noted by both Jeff and Paul in the room, the dock does not interfere with either the land court version or the extrapolated longer version of that easement or that right of way.
And it's certainly not on property owned by an abutter or property that we know is owned by the town of Cohasset. It doesn't have any deed reference attached to it.
All right, I'm still,
Take a month and review the supplemental material.
yeah, but the thing that's puzzling me at the moment, looking at this and looking at this. This site plan goes out, this property line along here, goes out, and then it stops, and then it kind of turns right, and goes out this riparian division line. And where's mean low water?
So mean low water doesn't even exist on this plan because it's so far, basically the Little Harbor drains almost.
Right,
So you're, according to the 1641 colonial ordinance of 1641, where riparian property owners have rights to the low water mark or 1,615 feet. Whichever is shorter. So as far as extending this out, we're showing it extending out to essentially the tidal flats.
mm-hmm,
And the method that we used was the colonial method. So basically, that method is connecting these endpoints where they intersect the mean high water line. So you connect your endpoint to your property line here and the endpoint of the property line over here with a straight line.
okay,
And you do the same thing for the abutting property. And you draw a line perpendicular to that for both properties. And if there's a overlap, then you bisect that and share equal distance with the riparian division line.
But the subject of the application is the registered land parcel. And every dock by definition would go
in the water.
into the water. Exactly.
point.
So it's a correct interpretation. It's an interpretation as to how it all fits. At the end of the day, this is definitely meets your definition of private dock.
Yeah, no question about that.
And so the question really then becomes, your definition basically says that it can't be on the property of another,
Mhm.
which it's not. And that it can't be more than 20 feet in height, which it's not.
Mhm.
And that it can't be more than a certain square footage of ground cover,
200 feet, but this is far from that.
far from that. So those are the criteria. We believe we meet the criteria. And the purpose of the floodplain really, right, which is to make sure that these structures are safe.
Mhm.
Because they're located in the floodplain. So with all of that, that's why we're asking for a vote to approve, because there's no information that would indicate anything contrary to us meeting the.
I think the only thing that was troubling me is setback. And where the property line is, to determine where the setback is on that float.
However, this, what's his name? Brian Nelson has clearly spent a lot of time looking at this. Sadly, he's not here tonight to help us explain. I would like to.
You see it?
Oh,
Yep.
I was, Like
Does
to
anyone
give a
else on the
little-
board have anything to add at this point?
No.
Okay, let's see who's up there.
While we're waiting, this is Andrew Astley. I'd encourage you to listen to his comments and see whether they are supported by anyone with an engineering background or with any information that has been supported by anything other than hearsay and Googling answers. Because I think we have answers to any one of his questions that have been done by surveyors and stamped by the appropriate people.
Yes.
Would you mind asking him to unmute because his hand is raised and he's not unmuted.
And who is it?
who's the he?
Brian, you know.
Oh, the
It's
one-
Brian Nelson. We see your hand is raised, but apparently you're muted.
Yeah.
Noted as panelist and he won't unmute. But his hand is. Question in the chat.
He has a question in the chat.
He has a comment in the chat. It says this survey.
Sorry, I'm Brian.
Oh, hi.
That's why your hand is still raised.
Oh, is it? Yeah, sorry.
Okay,
Oh.
we actually are awaiting your comments.
Oh, excellent. Sorry.
Can you go to the podium, identify yourself, name and address, and go from there?
Hi, I'm Brian Nelson, 40 Joy Place. Thanks. Yeah, I had trouble with the with Zoom, but I live close to it, so yeah, there were a few issues. The first, Mr. Chairman, you talked about the right riparian line. And so if you were to compare the Cohasset assessor's map versus the right riparian line, you'd see it's very different. And so instead of the straight line method, they've used this like obscure angular bisection. And so it's able to give that more frontage. But if you compare it to the Cohasset assessor's map and the 2019 cemetery survey that surveyed the boundary line, that actually has what you call a normal property line. And so by using this obscure method, they've got more frontage. They can clear the setbacks. And so that's a very interesting approach, but it doesn't really gel with a different survey, which is 2019. So what you've got is conflicting surveys. And so with respect to the right boundary line, I think it's a very good question of who owns the land, whether it's the town, whether it's the cemetery. And so you've got a stamped survey from 2019, Mr. Chick, you might remember it from cemetery, stamped by a land surveyor, stamped by a professional engineer.
Do we have that as part of our material?
You do, just today, I was traveling, so that's the small image, if you're able to blow it up, you can see,
It's right here.
it looks like the Cohasset assessor's map. And my apologies to the applicant and team, I only got that today.
Is that survey marked by a land surveyor or is
It's-
that by an
it's-
architect?
It's marked by a land surveyor and a professional engineer.
We haven't received
Yeah,
that
all
information.
questions come to the board, please, and then we will relay them back out.
My apologies.
That's all.
And so I'd say, I wouldn't say, at least on these grounds, I wouldn't say to deny the permit for this. But at least it's a big enough question to ask for peer review. And so let's look at the method. Let's look at the 2019 stamp survey. Let's look at the assessor's map. Let's look at the good work Paul did. And let's get a clear view on what the boundary lines actually are.
Can I,
And that's a separate issue from the easement, which I think I walked in on, sorry.
Did you hear the discussion about the easement earlier?
I did, there was a couple things I disagreed with, yeah, but I don't want to confuse the boundary lines and any questions that the applicant may have.
Okay. I understand your concern about making sure that your right of way is preserved.
Yes,
I did note that you had discussed a little bit about setbacks from the right of way. That's our setbacks are calculated to the property line.
yes, so I think there's actually two issues with the easement. The first would be, I think, 300 2.1 with respect to infringement, and so there was a little bit of discussion that I heard in terms of the land plan. So the land plan there is from 1950. If you look at the site plan, I think Paul and team actually have it accurately captured now on where the right of way, it runs from the roadway to the high water line, not low, high water line. And so if you're standing on that high water line and there's a dock right there, I forget exactly, I don't have my notes in front of me, 10, 15 feet, but then you put a boat there. And how do I launch a kayak? How do I launch a small inflatable? It's really on top of it. And so that's with respect to infringement. Setbacks is a separate issue, which I'm glad to address, but I just wanted to explain one of the main concerns there in terms of, we bought this house a year ago. Marketed with the right of way. It's one of the reasons we bought it. We actually bought it from Andrew. He owned this house before. He owned this one. And so it's very close. And so trying to launch kayak, small inflatable with the dock there, trying to navigate and maneuver in and out, add a boat, it's very difficult. I'd actually be forced to walk over the town land to shoot it out to be safe, which would be a trespass. And so if you can't really use your right of way without enough space, it's not good. It's certainly bad for enjoyment, bad for property value.
Although we have had testimony saying that the town, that no one owns this.
That's certainly an interpretation. I think my interpretation is if you've got the land plan from 1950, you've got salt marsh accretion. And so the deeds are actually showing property lines to Little Harbor, Meanlet Water. And so as salt marsh accretes, you actually get more land, just like if you erode, you lose more land. And so here, this property is actually accreted land since 1946. And so they'd actually own that land until the high water mark, just like the cemetery would across their property line, just like the town owns across their property line. So when you look at the Cohasset assessor map, you see that. And the survey shows that accretion.
so a couple things. Number one, town assessor maps are not. Number one, town assessor maps are not to be taken as actual property maps, and I don't think that your assessor would be qualified to pass judgment on the colonial ordinance. But separate from that, I invite Mr. Nelson to produce a deed if he believes that there is fee ownership to that land behind this property. And absent that, then I don't think that you can infer that one exists. I think actually you probably can infer the exact opposite. I do note that Mr. Nelson lives on the opposite side of the street. I note that the cemetery provided a letter of support with the Conservation Commission. We have not provided it to you, but we can get that to you. And there's no one that can tell us whether that easement goes to mean high water, because it only goes as far as the land court says it goes. Whether mean high water is accreted to be further out or not, it's where the land court says it is. We're being gracious to show it on the exhibit plan to give you an understanding that we're making certain to respect that if you were to extrapolate it out. Bottom line is there's plenty of room, and you can see that on the plan, for a kayak, for instance, to access the water utilizing the right of way. And there's no information in front of the board as to the purpose. Or any language that talks about anybody's rights to utilize it to launch a boat, for instance. So there's a lot of questions concerning Mr. Nelson's statements. As far as the survey that was provided to you for the cemetery, I would like to do that, because my understanding of that document is that it was stamped by an engineer. It was stamped, but that an engineer stamped it, not a surveyor. For Cabanero Consulting, there was just a general comment on the plan, because no one was really focused on this particular issue or that project. So no one really questioned it. Those would be comments for that.
Andrew asked, has a question.
Mr. Ashley, go ahead.
I just wanted to note that the work that was done on the riparian lines and the setbacks were done by certified land surveyors. No information that's been provided here by any party other than us has been done by that. Paul, if you would, if we have an opportunity, we can show that work has been done and shown on the document, to show that the dock itself and the floating portion is not in any way close to that 15-foot right of way. So this idea that somehow somebody can't walk or would have to go on other property in order to get out to free water is just simply false. The facts are the facts on the piece of paper that has been done by a surveyor and not by somebody that is simply, creating questions about this process without providing any additional work done by anyone other than his analysis of documents, and no additional work done around engineering or surveying. So in my view, we have to look to those people that are professionals in their assessment of what is the right way of measuring. And that's why we hired professionals to do this. And we have, I'd like to understand if there are other professional questions about the setbacks or the easement, or indeed the ownership of this property, that would cause you pause when we are providing all of those facts to you today.
May I rebut?
You may speak.
Can I speak well? I agree, I'm definitely not professional, I'm just doing my best. So I've got the stamp here, that says that the 2019 survey was stamped by a professional land surveyor and a professional engineer. And so, I'm glad to show it. If you want to see the stamp. May I approach?
Sure.
So I'm gonna try to keep everyone involved here. So this is the broad view that.
This is a cemetery?
This is the cemetery from 2019. And so you can see this in 20, so you can see the plots that are there. And then if I zoom in on the seals. And so my point isn't that, like, I'm definitely right and they're definitely wrong. There's a significant question here for the property manager. I mean, it's drawn in a very obscure, well, it also, if I may point out right here, you can see that the riparian line is 10, 12, 15 feet back on land. This is a grave site here. So there should be sufficient question, I think, for a peer review. I can discuss the angular bisection method referred to here as the colonial method. With respect to this 2019 survey that's stamped by professionals. With respect to the other point about who owns the land, it was my understanding that Mr. Astley owned the land. That's how the parcel map says. That's my understanding of a property deed and land court document that says from X roadway to the water line. And so that's what Paul and I had discussed at Concom. And so he did put that on the deed, put that on the site plan, which I think is accurate. I didn't provide the deed because I thought that was agreed to. That's probably my mistake.
Well, I'd just like to sort of parenthetically say that great that you have a photograph on your cell phone and a deed, and anything referenced here has to be submitted to the board.
This was
hard
submitted.
copy.
Yeah, this was submitted just today.
No, I understand, but I just, you know, we've got, you know, hard evidence in front of us and other things coming in. I think in order for us to digest this and deal with it, it all has to
Is this the cemetery?
end up,
Agreed,
but that's a,
and I think there's just two issues here, just because I think good discussion, fair debate here. And so the issue is whether the boundaries are correct or whether there should be a peer review ordered. And the second is whether it's infringement. Right, so the right of way comes right up the line. I think it's like 15 feet. With a boat, it's like less than 10 feet. And so how do you launch at 14th? And so that's another point. But the third point that you had mentioned actually it started down that path is with respect to setbacks. And so you can see from the site plan, the riparian, what they're calling the riparian line, even though it's over the salt marsh, is 28.7 feet. And so that makes them compliant with CBA 20 feet, and it makes them compliant with US Armor 20 feet. But a dock structure consists of a pier, the ramp, and the float. And so when I've seen setbacks, it's usually how far are you from the bordering water rights, not the land rights, and it's from the float. And so it's all one structure, and it was the exact reference is in the note I sent, but I don't have my notes in front of me. And so I think the question for this committee is, where do you take setbacks from? The pier itself, the ramp that's part of the structure that's tied on, the floating platform that's tied on but seasonal. And so when you look at some of the definitions on other setbacks, it also includes tents and bins. And I think that's a pretty strong supporting that even though something is movable or seasonal, something that's there 4 or 5 months of the year should still be measured as part of the structure and setback. And so I think that's a really interesting question for the committee.
well, yes and no. The zoning board doesn't have jurisdiction below mean high water. Frankly. And the other thing is that we had a somewhat similar situation about 1.5 years, 2 years ago in Nichols Road, where we had that right of way that went by Ben Lacy's property and
Oh, yeah, yeah.
others. And the right of way is the right of way. The end of the right of way doesn't also give one an extra 15 feet or 5 feet or 2 feet, you know, on either side or beyond it. It's simply access to the water and the ability to launch one type of craft or another, or is not part, unless it's
Yeah.
specified in the right of way.
The deed that I saw, it's water access to the high water line. There is nothing in the deed that specifically says you can launch your boat or stargaze or watch the birds, none of that. But it is usually the interpretation that any deeded right to water access comes with reasonable access to the water.
Well, if you can find evidence and submit it to us, great, you know, a court case, law, you know, fine, but we just can't say or accept that it's customary to,
I understand.
include something extra,
Fair.
without factual, support.
Fair.
Was the, can I ask, was the deed provided to the deed which is referenced here as far as what the actual easement scope is? Was that provided to the board today?
It wasn't, I didn't think to submit it, I thought that was a fake, with respect to the site plan.
Well, we'll continue this hearing, so if you want to submit it in the interim, you certainly can. I mean, I guess
But the zone,
go ahead.
sorry, the zoning, I think the zoning question is still outstanding with respect to where it should be taken from, and it's still high water line. My understanding, I don't have my notes in front of me, is that it still fails the setback on the right riparian line as they show it, under 20 feet from the ramp to the setback. And so if that's the correct application, 20 feet, it's in the RB district. So if it's 20 feet, then I think it would fail that as well. But also, again, back to, where we were a few minutes ago with respect to the wide angle. If you start the water line on the edge of the property, then they lose several feet. If you start it at sort of the normal angle from the Cohasset Assessor's Map, but more importantly, the stamped survey from 2019, the setbacks fail under ZBA, not under RB. But I think all those things can be addressed.
Yeah, I would encourage you to, you're making some interesting assertions, so if you could kind of help us with a little more, fact-based.
My first time, but yes.
Yeah, no, it's not a criticism, it's just that it's difficult to deal with assertion.
That,
Does the committee, does the board have a point of view on the appropriate measurements back, whether it's the flow or the ramp, or is that something that hasn't really been addressed? I couldn't find it at least now.
that's a good question. We certainly have jurisdiction over the setback to anything that's up to mean high water. After that, we don't have any jurisdiction, over, say, piers that are going in the water.
Mhm.
We don't count that toward the ground coverage. But I'm not,
Because you'll see on the site map, it's interesting, because of the contours of the mean high water. We take it from the most permissive, which is where they draw it from, versus the least permissive. There's also a big gap, so it's another, I think, we'll call it fun question for the community to deliberate on.
Structure.
So
It
there's-
is a structure.
it's a structure, yeah.
That's right here. That's this is what he submitted.
Well, you've got the site plan up too. I think it's related to this question, but there was a separate issue addressed in the letter with respect to the total square footage. So this is in a floodplain. It's an AE floodplain, FEMA floodplain. And so there is a number, I think it's 309.4 G5 that talks about a maximum cap on square footage for dock structures. And so the concept there is that we're thinking, the zoning bylaws are trying to put a cap, especially when it's in a floodplain at 200 square feet. The
Right,
entire dock structure is above 7 square feet.
but we have never counted anything above the ground itself.
And so that's an interesting point. And so in that instance, the ground coverage here, your interpretation of ground coverage differs from FEMA's.
It may, but our bylaw it's been on the board a few years and we've never, ever.
There, and I point that out as guidance. Of course, this is your own decision. The other thing I'd point out though, with respect to the local zoning bylaw, is if you're gonna build a dock structure that's 700 square feet and has 5 square feet or so of ground cover because it's touching the ground, you could, of course, have, with that ratio, you could have a dock that's 3,000 square feet and be well within your parameters. And so to say that it's only quote touching the ground could be interpreted to negate the efficacy of the rule at all.
Yeah, fortunately, we're not the only people who look at this.
Okay.
Our, zoning jurisdiction is limited. Concom looks at it, the state's gonna look at it on chapter 91 license, I assume. So it's not, we're not the only voice,
Yeah,
but we can only voice our opinions or our findings up to our edge of our jurisdiction.
Agree, and I think with respect to this rule, it is within your jurisdiction on the size of the square footage, it's the specifics of law versus CBA. Concom didn't actually address restrictions in the floodplain with respect to the dock, it was mostly on aesthetics, because it's in a very pretty area. I think there were some other comments submitted by the public that agreed.
Excuse
So
me,
they didn't address that, and I think you'd actually have concurrent response or concurrent authority within your jurisdiction to consider that rule that's here. So I think it sounds like we're headed towards a continuance anyway, but that's something to consider. I think there's a few interesting questions there.
Thank you.
You guys have consistently measured the square footage of what goes into the ground. Not what-
Right.
In all your decisions on that, so that's kind of.
Particularly if what's above the water in this case has some pervious quality to it.
Yeah.
We're not, you know, I mean, if you put a concrete, whatever,
Consistent decision
yeah.
maintained.
Well, I'd asked the zoning, and that was with respect to docks, but if you've got a porch that's extended on stilts, I think that still counts as lot coverage. Same thing
Depends on
with a
it.
house that creates up on stilts.
Depends on if it's permeable or not.
Underneath, okay.
excuse me, Chair.
Mr. Astley, did you have something else?
I did. I just was wondering whether we're gonna just let him continue to just talk, or does he have questions or information to share? Because
Well,
it seems,
you know, we'll let, our general practice is to let people talk. We listen. We have questions, we ask them.
all right, then I
and we
would
take in
encourage you to,
everything- We take in everything that's in front of us
Take
and
his
go from there.
hearsay about things like wasn't covered at the Concom. What was or wasn't covered is not something that you should look to the notes on Concom. They approved the project. That's the end of the day on that subject.
No, we only consider what's before us and what's our jurisdiction, so.
Yeah,
We,
thank you.
we often hear a lot of things that we don't really have much to do with, but we still listen.
Fair enough.
They just.
Sure.
So as far as setbacks, I did review the setbacks from the building department, and I was told that they would only apply to the fixed actual dock structure themselves, it'd be a 20-foot setback. Then also with respect to the property line shown on the cemetery plan, they basically end their survey right at the land court plan property boundary, and then just draw a general arrow saying to mean low water. They didn't really examine anything out further than that. We've also done an alternative plan, which I can pass over to you, showing we were to basically take our riparian division line and include the cemetery's wall and draw it right from the corner of the cemetery's wall, but we'd still meet that 20-foot setback to the structure. I've got a little red line sketch. I understand that it hasn't been submitted beforehand, but it just kind of adds that it would not impact the setbacks to the structure.
Hey, you will also with the building department.
I mean, I think pretty much all the dock applications that we've come across for years just show the property line going straight out into the water. This is the first time I've ever seen this colonial 1624.
A lot of times the general property line kind of goes to perpendicular to the river in a sense, so surveyors just kind of keep that consistent going right out because it doesn't just come perpendicular to the river. We get some of the irregular properties and you still have rights to the low water mark in accordance with the colonial ordinance of 1641. You have to use different methods to share access with riparian property owners along that water frontage. So this is a common method that's used in New England. The straight line method that Brian's referring to is actually, probably give you some more information on how that's not the correct method to use. Which we'd be happy to provide for the next meeting.
Yeah, I mean, I just want to make sure that that this is being built on
Right.
the owner's property and not somebody else's.
Yeah. Understood.
Yeah, we'll probably have a response to, once the submission from today is forwarded to us, we have an opportunity to review it. We'll probably have a response to that. But I'm reticent to respond to that until I receive any supplemental response from Mr. Nelson, because I don't want this to drag on hearing to hearing to hearing.
Mm-hmm.
So if you're going to continue, which I understand of course, there hasn't been a zoning hearing, I was telling Mr. Astley, that I've been involved with in this town that's closed on the same night. I understand that, but I would ask that Mr. Nelson provide all of his materials within 2 weeks prior to the next hearing to give me the 1 week that I need to respond to all of it. And for it to be timely submitted to you, because I understand, I think that your deadline is 1 week prior to the meeting. Yeah.
Is that all right, Mr. Nelson?
That's more than fair, yeah.
Okay, great.
Great, so we'll address the issue of the Colonial Line and anything that was in the email. If you have any additional questions that you want us to address, let us know.
Okay. I would assume that there's some case law on this Colonial Line thing, but
Well,
Yeah.
you know, also, there are differing interpretations on this, right? So the bottom line is, have in front of you our land surveyor.
Mhm.
I don't know anything about like on there. Filed the plan that they filed years ago on behalf of the cemetery, or what the issues were. But sometimes applicants take positions on things that are in their interest at the time, and the bottom line is that I'm providing you with an expert here to my left who explained his position on this pretty succinctly. And I don't really have any information in front of me other than the tax assessor shows it differently and a non-locus application from years ago showed it differently. What matters is what our land surveyor says now and what's in front of you with respect to this application. From the only expert in the room, frankly, who has a good reputation of, you know, in many towns and isn't gonna die on this hill. If you,
I'm not questioning his expertise or anything.
yeah,
I've just never seen this before. And I'm looking for a little more comfort level, so.
sure.
I've got one other request too. I think we've had some interesting discussion about setbacks and rights of way and deeds and so on and so forth. But I've also seen some references to, here's one, the dock degrades the natural beauty of a shared resource. That also has to be factually based. It can't be somebody's opinion or impression. I not arguing the point with you, but I'm simply saying that that doesn't really cut it with the zoning board. We have to say that there is precedent. When this has been done before, it's degraded the value of land or it's affected something. I think you've probably got a stronger cases to make on issues of deeds and setbacks and whatever than aesthetics, even though aesthetics are important, but very hard from a zoning standpoint to support that without case law.
I think one other comment, I respectfully disagree that what the point is that we doesn't discuss. The locus is the property. And my understanding is for these special permits to be approved, it's on the applicant to show that this is clearly their land. So where there is question, back to my colleague's point about not wanting to waste too much time between certain courses. If the board is thinking about requiring peer review, it might be better. Who's better off sooner rather than later with request, and I'm not sure how. Also don't want to, have them drag on at this.
Just one other aside. It's generally not our jurisdiction to deal with legal rights over rights of way or property lines. We generally, our consideration is confined to the record before us. And if abutters or right-of-way owner holders or whatever have a problem, they go to court, get it resolved there. But it's really not our jurisdiction at all to decide those things.
I think it would be, understand that, I think it would be a function of the setbacks.
Mhm.
Step back to a deeded property corridor, and so that is it acts as a lot line without being lot line, I think that's sort of the question. And then just the measurements. of the-
Yeah, and that I would agree with.
So I think, thank you for that, I think that sounds like a stronger argument. I think there, I'm not sure if there's any, I've taken a lot of time, I just want to make sure there's some comments on Zoom.
Anyone else?
Before we get to Zoom, just very briefly,
Go ahead. Jeff.
just on the easement, again, I just wanted to note, the only easement that's in front of this board is like 10 feet long. Street that is shown on that plan from 1950. You're kind enough to extrapolate it out, but if we're kind enough to extrapolate it out, doesn't mean we agree that an easement goes all the way out there. I haven't seen any additional documents. I'm just looking at what's in our certificate of title.
I think for our
Yeah.
purposes, it doesn't matter. All right, anyone else have anything?
Nope.
Mr. Ashley?
No,
Good, okay.
Sorry, there's one more issue, and I thought someone else was on that, there's a few folks involved.
Would you mind approaching the microphone?
This project abuts the Cohasset Central Cemetery. And so there is a regulation, Cohasset bylaw, that when you've got projects like that, my understanding that when you have projects like this, they need to be reviewed by the historical commission, because this is actually a National Register of Historic Place. So
Okay.
that number is,
The cemetery is.
the cemetery is a National Historic Place as of 2004. And so there's a, I can find the number here, pardon me. Cohasset zoning bylaw 300-11.4D. 300-11.4D speaks specifically to projects that are right up against a National Historic Site, which Cohasset's view, and so the Cohasset Cemetery is one. And so, again, I don't have my notes in front of me, but it does require a heightened standard, and including an extra review from the commissions, from the historic commission, it's my understanding.
Well, doesn't this board already refer all special permit applications to municipal board departments or?
I believe it has to be identified as a national historic site, and I'm not sure if it was identified in your application.
What, sorry, you said 11.4D?
Let's get this right.
What is it?
I have here 300-11.4D.
Mhm.
Buffer area to protect. Farmstead, stone curls,
And so this would be I forget the dimensions exactly,
that would probably be the historical commission.
Historical, I think that's there might actually, the historical commission, there might be two commissions, but at least the historical commission, and so that's not something that would trigger when it's harbor master and 91 and DEP. This is something that has to be positively identified as abutting a national historic site, which this is, it just wasn't in the application.
Duly noted, thank you.
I don't know if a buffer zone exists or not. I mean, it's not come up.
Well, I of course argue that it's on the cemetery's property, but I'm done.
Again, we have a letter of support from the cemetery, which will.
Was that submitted here? Because the cemetery's letter of support was specifically about flooding on the seawall that I read,
No.
and I don't believe that was submitted to ZBA.
No, we will. submit.
Yeah, thank you. We haven't seen it yet. All right. Anything else? Anybody?
Motion to continue to
Second?
our next meeting.
All right, it's been moved and seconded that we continue this hearing till our next meeting. Dave McMorris, aye.
What should a guy?
Lee Darcey.
Yeah, Fernandez, I.
All right,
When is the next meeting?
well,
Determined
good
yet.
question.
It's
December
regularly
1st.
scheduled for December 1st. And
Right.
I didn't know if the board wanted to discuss adding a November meeting or.
I think, I mean, we had a time pressure on one application that's been dealt with, so,
So it will be December 1st.
yep.
So we'll have these submission and deadlines that we talked about 2 weeks prior to the one.
2 weeks and 1 week. Yep.
Thank you
Great.
so much.
Thank you.
Appreciate it. Thank you.
And if you can find a way to get a bit more legible copies of the stuff that you gave us tonight, then that would be great.
We have a third hearing, but
We
nobody.
do have a third hearing. You're not here on that, Jeff?
No, no. Thank you.
Oh, don't forget your drawing.
Beautiful.
Have you heard anything about this, John? The ADU application?
Yes,
Oh,
good
here we
evening.
go. All right. I forgot that you don't have to be here.
Yes, good evening. Sorry about that. I apologize. So
Okay,
I
The next hearing is 149-151 Hull Street. It's for a ADUL. Applicant is Kenny Larkin, and you are
am Kenny Larkin, yes.
Kenny Larkin?
Yes.
Hey, welcome. Want to give us a little outline of your project here?
Yes, absolutely. I hope to make this short and sweet. I don't want to take up too much more of anybody's time here. So just a little background on everything. I came under agreement on 149, 151 Hull Street back in May with Doug and Paige Scott. And I was under the impression at the time when we came under the agreement that the ADU was approved. Once I started digging into everything, I met with Mr. Hallen numerous times. Come to find out, the ADU itself was only approved by environmental, and the appropriate steps had not been taken. So I was granted an extension on the closing with the caveat that I obtain a permit to build the ADU. In going through everything, all the plans that you guys have, in speaking with Mr. Hallen, the structure that I am proposing is 1,162 square feet. The legal size of an ADU is 900 square feet, so this is 262 feet larger than an ADU. The reason for that is that it's actually on an existing foundation. So what's there right now, 149, 151 Hull Street, is a legal two-family home with a detached garage, two-space garage. And this proposed ADU is going to be built directly on the existing foundation that is there now. So keeping obviously the same footprint, just going up 2 stories. It's a 2-bedroom apartment.
All right. As you know, the state changed a lot of the laws regarding ADUs. And for ADUs that are under 900 square feet, there's kind of an absolute protection. There are very few restrictions that a town can put on it. For ADUs over 900 feet, the town can put restrictions on it. Our zoning bylaw requires that any ADUL, which this would be owner occupied, either the ADU or the principal dwelling. Do you intend to occupy it?
I do not. I did not know that that was part of it. No, I do not plan to occupy the premise.
Okay,
That
it's-
automatically disqualifies this application.
So under 304.3, it's 4.3 dash 1.1 underneath the first section says the owner of the subject premises must live in either the principal single-family dwelling or the ADUL as his/her primary residence. And that's a foundational requirement for this size of an ADU. If the ADU was under 900 feet, that's not a requirement.
Okay, I do understand. and I apologize, I did not know that. You know, I've been working this process since May. And like I said, I've had many sit downs with John, and I've had sign off from the Treasury Department, the Sewer Department, the Storm Management agent, the Fire Department, and none of that was brought to my attention. But again, you know, I am trying to comply with both the aesthetics and the functionality of this ADU, and I've gone through the process of subcontracting both Merrill Land Surveyors and the Colwell Group to maintain the character, scale, architectural integrity of the existing property, rather than having it just be a parking garage. So I do, I guess my question is if there's any variance from the owner occupant requirement there.
I would, well, you can always apply for a variance, but the criteria for a variance are pretty clear and pretty strict, and I doubt very much that you would meet them.
And you can't get a special permit for this application. I think there are 2 or 3 other conditions as well. 4.311 again, section D says an ADL large must have been in existence for at least 10 years. And you propose to tear down a building and put up something new that's twice as large. And in fact, there's also section E under that that says, except for any lawfully pre-existing non-conforming structures, when an existing building must conform to dimensional requirements, any structural change or additions must also conform. In fact, if you measure the drawings prepared, you're using a larger footprint. The footprint today is basically 24 by 24, 576 square feet. You measure it out, it's 625 feet. So it's a larger footprint. That's the way the drawings are that have been submitted. If that wasn't your intention, okay, but the drawings are incorrect and would have to be redone.
Well, the drawings are 24 by 24, correct? The architect that
No.
I had came out and measured the existing foundation.
That's what you have today, the 1-story garage.
Yes,
24
correct.
by 24, but if you go to the
So I apologize for cutting off. Where are you getting the 24 by 24 dimension though?
that's on the site plan. Prepared by Merrill.
Merrill?
Yeah. 24 by
So-
24.
There could be different points of where that dimension is taken because there is inside the
square.
garage.
It's a square.
No, I
It can't
understand,
be
but there's also a concrete shelf on that, so they could be taken from the outside of the shelf or the inside, which varies.
Well, I'm seeing 2 different dimensions. I'm seeing a 24 by 24 existing and what the heck is it, a 25 by 25, basically.
And I completely understand that. I'm not arguing that fact at all. I just the architect had come out and has measured this, so my assumption is that they took it from the outside to the outside, and what Merrill had is probably inside to inside dimensions.
Well, it
So
has to
there's
be
the
reconciled. If you
Look-
want to pursue it, it has to be reconciled, but right now there's a discrepancy. And that would kick it out as well, because the bylaw says if you're going to build new, it has to conform to dimensional requirements, including frontage.
It does. If you look on the 5th page of the Merrill sheet, the frontage in the top right corner, it actually shows you how they calculated it. And I did sit down and review this
Trust me,
with John as
Merrill
well.
is wrong. That business about measuring a dwelling on either side applies to principal dwellings. It doesn't apply to accessories. And this garage is an accessory structure, which would now be an ADU. So you can't apply the dimensional dwelling setbacks to a structure. So that also would kick it out. I mean, I think you'll probably have at least 4 violations of the zoning bylaw here.
And
What I think.
you know, part of the problem with these ADU applications is that all the ADU law is new. And our bylaw is actually quite new. I think what I would suggest, and it's up to you, we have the application in front of us, we opened the hearing. So, you know, our choices are to continue the hearing. At some point, we're going to close it and we're going to have to deny the application because of just starting with the the owner occupied issue. The other alternative is for you to ask that you withdraw the application without prejudice. And then you can, you know, if the problem is if we deny it, then you can't come back for 2 years with any similar proposal. If you withdraw it without prejudice, you can come back whenever you want.
Okay, I mean, I definitely don't want to push this out 2 years. You know, I do apologize for any oversight. It was not my intent. You know, and like I said,
It's no, you know, we understand it happens. So
Just on the clarifications.
Uh-huh.
Question, so the
Can he
ADU
hear
large.
Can you hear?
Oh,
yes, I can hear John. I can hear John.
Oh,
Okay.
I didn't know he could.
yeah, on the ADU large, once we're at 901 square feet, that kicks into the large territory. So when we review that, you guys are reviewing the whole ADU or just the portions over 900s?
The whole ADU.
Right, no, I want to kind of clarify.
The whole
that.
ADU.
It puts it in a different category.
Right, as soon as it goes
So
to,
they're saying there's 1 and 2.
yeah, because the bylaw is divided into ADU and ADUL. Everything over 900 square feet is in the L and has to comply with all the provisions.
Got a more question to
Yep.
clarify that, so.
Also, and if you're going to resubmit it, the way I think it's the Merrill plan refers to this new structure as a guest house. Not a
Yes,
good idea.
correct.
A guest house is a very specific item that you can't charge money for and is used intermittently. So
You don't want it to be a
you
guest
don't
house.
want it to be a guest house.
No, I do not want it to be a guest house.
I mean, you know, that's just a small picky point, but,
Sure. No, I want to do everything by the book. I'm not looking to
Right.
get around this at all. But as I
No,
did
no,
mention,
know. They-
some of this stuff was
They should have
done.
picked that up.
Yeah, some of this stuff was done prior to me purchasing the property. So that's not something that I had picked up.
It was probably done before the new bylaw too, which makes a difference.
Is there any way that I could get grandfathered in under the whole bylaw or
Nope, sorry.
worth a shot? Worth a shot. I
You
figured
don't
it'd be
own
easier.
the
than that.
property yet.
I do own the property. I do own the
Oh, you
property.
purchased it?
I did.
See, but if you're adding a second story, you're probably gonna need either a variance or something. I mean, he's doubling the volume or more.
So I
It's
thought that was
acceptable.
actually what the petition for the use of the special permit and then a petition for a special permit was for the second floor. Is that, John, I guess, do I have to address, wasn't that what we kind of discussed?
I don't know, we haven't decided it, but I would view it as a variance. He's doubling the volume, more than, even if he fixes the square footage footprint. Wouldn't you think? Because the bylaw says it has to comply, anything,
Mm-hmm.
Any structural change or additions, this is out of the ADUL. Number E, any structural change or additions must also conform to applicable dimensional requirements or obtain appropriate zoning relief. Well, I don't know, we could decide whether it's a special permit or variance, but
But, footnote E before that, says acceptable law will break between non-conforming buildings.
yeah, but the building is being torn down and being replaced by one much larger, and I would argue with a different footprint. So it's
Well-
not the reconstruct, it's not a lawfully pre-existing non-conforming building. It won't exist anymore. I think.
Well, I don't know if this sways you in any way, but there is thought to keeping the structure itself and building on top of it and infilling the garage doors rather than demolishing the building itself down to the slab.
That would seem reasonable, but you're gonna need a different drawing, because the drawing itself doesn't support your intention. The dimensions of it. Because any structural changes or additions to accommodate an ADUL must also conform to the applicable dimensional requirements or obtain appropriate zoning. And yeah, you could say maybe it's a special permit, but maybe it's a variance if you're more than doubling a non-conformity.
I think if you're keeping the original building and building on top of it, that's a lawful pre-existing non-conforming
Okay.
building. So I think you're in special permit territory or,
Well, the drawings,
maybe
I'll
even-
have it as a tear down and.
right,
and
the drawings are gonna,
So
the drawings are,
Drawings are not
Right.
viable. Or, I don't mean not viable, they wouldn't meet that
Mhm.
requirement as a modification of an existing structure. I mean, the bylaw is pretty clear, I think.
Mhm. And the principal dwelling is more than 1,250 square feet
Mhm.
and it's been there more than 10 years, right?
Well, the principal's
Yes, it is.
yeah, if you're modifying the principal single-family dwelling, it's got to have existed for more than 10 years. I don't know how old the garage is. It must probably date to that same, whatever that date is.
Mhm.
Well, your application said 1850 for the.
Yes,
I'm sure.
I
the
believe it
garage
was, yeah.
Built then. Garage must have been built in the 1950s, probably. from the looks of
Yes,
it.
I don't have an exact record of when the garage was built, but I'm
Yeah.
positive it was over 10 years ago.
Right. So what do you want to do?
I would like to take your recommendation, and I guess whatever you feel is the best path to take, that's the way I would like to go.
Okay, I think you're best protected if if you request that we withdraw the application without prejudice.
Okay, and I have to apply for a variance?
No,
If you want to avoid that, if at all possible. And I think you can.
yeah, you can, I think you can too. Well, I don't see,
Well, if the
I don't
building
see
is
how
torn
you're gonna
down-
do an ADUL if it's not owner occupied. I
Well,
just- I
that was
don't-
actually my next question, because that was the very first bullet point you guys brought up, and my intent was not to move there. So I don't know how I would actually get around that itself.
I don't think you can. I think the alternative is probably to get under 900 square feet. Then you can do it pretty much as of right.
Okay, that's probably the easiest way to do it then.
I think it's the only way to do it really.
Under 900
And,
square
and
feet.
concentrate on modifying that garage. I think once you tear that garage down, you're in a different category.
Well, that's
But once you s-
ADUL. If
Oh,
you're,
yeah, that's what I mean.
Yeah.
But, no, I'm not.
So if I do get it down to if I subtract that 262 square feet and I get it down to the 900, it is no longer the ADUL.
correct, it's an
Right.
ADU.
All right, so
And
then I
it
don't
comes-
have to focus on modifying the garage. I could
Would
just
it
make
be-
adjustments to the plans as they are and get it down to 900 square feet.
Could it be 2 stories still or no? Yes,
I
no.
don't think so.
Yeah, you'd have to deal with the total square footage. 900 square feet, maybe there's a bedroom up on the second floor, but not a, full scale.
But he's asked.
Second
if he
story.
can take it, the
What?
whole thing down and rebuild. Is that
Oh,
what
could
he
he,
was saying?
could he, are you asking, could you
If it's
tear
under
down the
900 square
garage
feet.
and,
Then I think he runs into trouble with the setback, front
Right, with the
setback,
non-conforming.
because
Yep.
it's accessory building, not a primary.
Yep.
So
Hmm.
I think Woody's idea of maintaining the garage gives you more rights at 9.
absolutely.
Right.
So it does. So you're suggesting to modify the garage rather than tear it down.
Right, and,
Okay.
and you'd have to figure out, what, that doesn't say you couldn't do something on the second floor, but it probably couldn't go the whole square footage of it, that's all, but,
And the square footage would be heated living area.
yeah, we don't count the basement,
Or basement.
yeah, or whatever. Right, we don't count
Unless it's finished.
Yeah, unfortunately, well, not unfortunately, I mean, it's just a fact, the way that bylaw was crafted. They didn't want to see the Wild West again and have people build all sorts of structures anew, so. But it seems reasonable. I mean, you've got land and back and, all that stuff, good location.
Yes. So I'll definitely get on making the modifications with the architect. Is there any way that I could get on the next? I believe you guys said December 1st. Is that the next hearing?
Yes, December 1st is the hearing. I just have to check. the, Last possible submittal date.
Is it 2 weeks before,
No,
Julia,
it's,
or more?
it's 4 weeks in advance. You can use time for advertising.
So that's tight.
I apologize. I didn't catch any of that.
Oh, can you hear me?
It's muffled. It just,
Can you hear me?
yes.
Chief,
That would be too close, because of the time and advertising in the newspaper. So a realistic meeting would be the January meeting, which would probably give you December 1st deadline for submittal.
Okay. Okay. Well, thank you guys very much. I don't want to take up too much more of your time. Those first two were doozies there. So I
Interesting.
will I'll do my legwork and I hope to present to you guys again.
Just one question on the, just an email regarding the withdrawal of the application. If you sent to Julia to make it official.
You need me to send that to Julia?
Yes.
That you're
Okay.
requesting a withdrawal without prejudice.
Understood.
great,
Thank you very much.
thank you.
Okay.
Bye-bye.
Bye.
You got minutes, huh? We have to approve
Yes.
minutes?
We do.
God, that's something that'll go fast.
And then we should
And
probably,
we have Carolyn Murray in the participants as her hand raised.
I'm sorry.
Carolyn Murray has her hand raised.
Ah.
was she on the whole time?
She gonna tell me to calm down? Like,
Carolyn Murray's town council.
Yes. Is our town council?
Still muted.
There we go.
Hi, Carolyn.
Sorry,
Hi,
folks.
Carolyn.
How are you? I guess you didn't see my hand up, quick enough. But for that last applicant, if he changes to a 900 square foot ADU by right, there is no coming back before the ZBA for anything, nothing that needs to be advertised.
That's true.
So he could come back in December if needed, if he's ready.
He doesn't have
But if
It
it's a
doesn't have to come back at
900,
all.
Doesn't have to come back.
Okay, yeah, I get it, yeah.
if it's 900 square foot, he doesn't have to come back before this board at all.
I think the only trouble with that, the concern was the proximity of the front would be enlarged, the existing nonconformity in the front setback. That was the only question. He was, if he stepped back, he wouldn't have to, but yeah.
Well,
On
I
it-
guess we wait and see what the revised plans look like. But if he was just going to keep with the existing garage, but turn the, the main floor into an ADU and maybe some space up above, unless he is creating any kind of a height issue, as Woody was saying, it wouldn't necessarily require any relief from the ZBA.
Okay, that's right. I think that's.
Yeah, he's 576 square feet now on a single story. So he's got 300 and basically 25 feet, 24 feet to go. He could also, and I don't want to start designing it, but he could go out in the back. He's got a lot of room in the
Right.
back.
Yeah, then
Mhm.
he's setbacks.
And yeah, because he wouldn't be, exacerbating a nonconformity. He would be going the other way. He'd be beyond the
Right.
20 foot. So that may be a,
So it
So
remains to be
maybe-
seen what, but I didn't want him to be left with the impression that he has to reapply to the zoning board because he might not have to.
Mhm.
I would encourage that.
Yeah, I can follow up with him, via email tomorrow.
Okay, great.
Now, were you here for the earlier hearings or not?
I was here, yes.
Are we still on the record?
You are still being recorded, yes.
Well, if you have any legal advice to offer, after we close the record, we'll listen.
I think you did a great job, quite frankly, under the circumstances. So,
I'm usually calmer.
You were,
you were pretty calm.
All right,
okay.
all right. Our next, anything else, Carolyn?
Nope, that was it.
Okay, nice to see you.
Happy
You too.
Thanksgiving.
Happy Thanksgiving. Oh, I'll see most of you in another week at town meeting, I'm sure.
Oh, right, right.
We waved to
Monday
you
night.
from the audience.
All right, good night, folks.
Good night.
And I,
So we have meeting minutes from October 6th.
Motion to approve the meeting minutes from October 6th.
Second,
Been moved and seconded that we approve the meeting minutes from October 6th. David McMorris, aye.
Major Kai.
Lee Darcey.
Leah Hernandez, aye.
I don't think, when we, on the Elm Street, we voted to deny. I don't know that we voted to close the hearing.
I don't believe,
Do we need to do that?
I would say probably
All right.
type things up.
All right, I'd move we close the 9195 Elm Street hearing.
Seconded.
It's been moved and seconded that we close the 9195 Elm Street hearing. All those in favor, David McMorris, aye.
Major Kai.
Lee Darcey.
Leah Hernandez, aye.
Right.
Um,
So our next meeting is December 1st, correct?
Correct.
Great.
Anything hot coming up?
Also, can we discuss maybe the January, February, March? I mean, are you going to be here or should we have them by Zoom because of the winter.
Well, the chair has to, whoever's chairing the meeting has to be here live, right?
Like a hybrid meeting, the chair has to be, if they're remote and someone else.
Okay. I expect I'll be here for the January meeting, but I will not be here February or March. I'll zoom in.
I would, no, I would just say that this meeting is a good example why a hybrid works, because with these plans being passed around and finger pointing over here, we never could have done that with, computer screen
Mm.
effectively.
Well, yes and no, because we would have had a pointer.
Share.
I mean, we did it for 5 years.
Right,
We
people
would have
would
had
have
a
shared the-
pointer on it,
Share the
yes.
thing up there.
And they wouldn't be running around pointing at it. It would be highlighted.
Okay.
And it would be, because we
Yeah.
did that for 5 years.
Mhm.
I just think maybe in the winter, if we just had the remote meetings, that
Well-
would be.
But also, wouldn't, like, all the documents that were floating around that were very last minute, those technically shouldn't have even been considered here?
No, they shouldn't have been.
they should
Right.
have been.
So if we were all virtual and couldn't
Yes.
see what they were holding, then we would have to say,
Next
you
time.
need to
Yeah.
resubmit, so we
Be
can
part of
all
the
view
record.
these
Yeah.
5 weeks ahead or whatever,
Yes.
the requirements.
Yeah.
Because I feel like that was a lot of information very last minute that wasn't actually fully submitted because someone who's new, who was never exposed to the case prior, all I saw was what was here. And I saw some things from all I saw was here, and that's it. Like there was no other information. So
Hmm.
if they come, and it's the same thing with the doc. There was 3 different versions of
Right.
a survey. And no matter if they handed it to us regardless, we didn't have any time to review it,
Right.
so.
Well, we never vote on anything the
Sure,
first time.
of course.
And then we told them.
But
that they
still,
have
in
to
order to
make it.
consider that, we
Yeah.
technically, that needs to be submitted
Yes.
well in
Yes,
Yeah.
within the
Mhm.
confines of the
Yes.
deadlines,
yes.
submitted, printed, so we can pick it up and review it. Like, I mean, this was a lot, I've looked at it, but the stuff that they presented tonight, it was, hard to even just reconcile what was
Mhm.
what was actually the correct plan to even go by, so.
Yeah, so I just want to address your question because, so I forwarded that material to you, but, with the item that it's to your discretion to review it at tonight's meeting or not. Like going forward, we can prefer any materials submitted after the submittal date is passed, just not provide it until the next.
No, or just be at least marked like this
Well,
has
what-
been submitted after the deadline.
Yeah.
And if you don't have
Yeah.
time to review it, I mean, if it's a simple thing, fine, but like the 2 additional drawings
Yeah.
that were presented in the meeting, I couldn't reconcile them right here on the spot. I didn't have a reference to the town records. So there was no way for me to kind of just like understand and double check like what was
Right.
fact versus what was, or the engineers, whoever stamped it, like,
Yeah, well,
how do
that was,
sure.
the reason why they had so many variations, because they probably couldn't decide which one they were gonna submit. And then they decided if and when that somebody brought up something, then all of a sudden they whipped out the other one.
Sure,
So,
regardless.
and they know, and the attorney has been before us so many times before, and he knew that we
The
were.
gentleman in the suit,
Yeah,
Yeah.
Jeff DeLisi. He knows that we, as he said, we never make a decision the first time.
sure.
So the first time, they just shouldn't, we've closed the meeting, right? Or have we? No,
No.
okay.
Oh,
Motion to close
But
the
it-
meeting?
second. All right, it's been moved and seconded and we adjourn. Dave McMorris, aye.
What did you guy?
Lee Darcey.
Leave it in aside.
Okay, so.
But either